Please be seated. Members, I'm conscious that the Honorable Deputy Premier, who is presenting the current bill, is not here. But we have something of a technical issue if we don't resume, in that by simply the attrition, the passage of time, we will reach 4:30, which is the hour of interruption. And then that would be the end of the day's business unless we call another sitting. So I am going to, Madam Premier has arrived. So if I could invite Madam Premier to move a motion to suspend Standing Order 10.2 in order that the business of the House may continue beyond 4:30. We can then suspend again and await the arrival of the Deputy Premier.
Mr. Speaker, the temptation is great to say, Mr. Speaker, the motion is, but I won't, I won't play a punch or indulgent. I would merely say the motion is, Mr. Speaker, with more seriousness, to suspend Standing Order 10.2 to allow the House to continue its business beyond the hour of interruption being 4:30.
Thank you, Madam Premier. Those members have heard the motion. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Business of the House will continue beyond the hour of interruption. And I will suspend proceedings briefly to await the arrival of the Honorable Deputy Premier. The clock on the wall is wrong. My watch is right. It might be helpful if members retain their seats for the little while. Parliament is resumed. Good afternoon, Deputy Premier. When we took the suspension to attend the meeting and for the Premier to hold the press conference, the Honorable Deputy Premier and Minister for Financial Services was presenting the Merchant Shipping Bill 2023. May I invite the Honorable Deputy Premier to proceed?
Thank you, Mr. Speaker. Let me just take this first opportunity to say, Mr. Speaker, for the historical context, that as we return to the debate in this House, we just witnessed, the country's just witnessed, an unprecedented show of nonpartisan support in the wake of the events last night in West Bay. I'd like to thank, on behalf of the Premier, all members of this House for taking such action, unifying and meeting with the Police Commissioner, and then the Leader of the Opposition, facing a panel with the Premier, the Governor, Her Excellency, and the Police Commissioner. Thank you all. It's therefore, Mr. Speaker, somewhat jarring to then proceed with a bill that may be perceived as more mundane. But at the same time, I did hear the Premier at the press conference say that the business of the country must go on, and we cannot be paralyzed in fear. So with that, Mr. Speaker, where I left before the break was to describe my approach to the bill, since it contains 466 clauses, was to instead do an insightful overview of each one of the 19 parts of the bill. Starting, Mr. Speaker, with Part 1 of the bill, which contains clauses 1 and 2, provides the short title, and for the interpretation of certain words used throughout the legislation, which includes changes in the definitions to reflect updated terminology and other legislation. Part 2 contains clauses 3 to 60, which deals with the registration of ships and matters related to registration. Mr. Speaker, this part provides for the procedure for the registration of ships, including the registration of ships chartered by demise to a qualified person, registration during the transfer of ownership, registration of alterations of a ship, and the transfer of registration between the islands and the United Kingdom, or a Crown dependency, or a sister British overseas territory. This part further brings the qualifications for owning a Cayman Islands ship in line with the UK's ownership criteria. Part 2 also provides for the rules as to the names of ships. A ship shall not be described by a name other than that which it is for the time being registered. This part provides that a change shall not be made in the name of a ship without the previous written permission of the Registrar of Shipping. Mr. Speaker, Part 3 contains clauses 61, 65, provides for matters related to the national character and the flag of ships. This part also specifically provides that it is an offense for the master of a ship, which is not a Cayman Island ship, to do or permit to be done anything for the purpose of causing the ship to appear to be a Cayman Islands ship. Part 4 contains clauses 66 to 80, provides for the proprietary interest in ships, and provides for the rights of owners and mortgages for the transfers and transmissions, and for other matters that are related to the mortgage of a ship or of a share in a ship. Mr. Speaker, Part 5, which contains clauses 81 to 126 deals with masters and seafarers and other related matters, including the minimum requirement for seafarers to work on a ship, the conditions of employment, the provision of food and water, health protection, medical care, welfare, and Social Security protection. It also outlines the civil liability that seafarers may face where they have been absent without leave, if they are found to have committed an act of smuggling. In addition, where ships are fined because a seafarer is found to be present in a country in contravention of that country's laws, the amount of the fine may be recovered from the seafarer. A procedure to be followed by the shipping master is also clarified in this part that preserves a seafarer's ability to seek or recover unpaid wages through civil action. Mr. Speaker, Part 5 also provides for offenses by seafarers in relation to the wearing of uniforms, conduct that may endanger a person or is likely to cause serious damage to a ship, its machinery and equipment, or any other ship or structure, disobedience of a lawful command, and making of false statements for the purpose of obtaining a certificate or any other document. In matters related to the fitness of a seafarer to serve on a Cayman Islands ship, if it appears that the seafarer is unfit to discharge their duties or has been seriously negligent in discharging those duties, Part 5 allows the Chief Executive Officer of the Maritime Authority to give notice in writing that the suspension or cancellation of any certificate issued to the seafarer under the legislation and regulations is being considered. The proposed legislation ensures that there is due process with such matters, providing for a hearing, rehearing, and an appeal process to the court if needed. Part 6, Mr. Speaker, sets out clauses 127 to 155 and deals with the prevention of collisions, safety of navigation, vessels in distress, and aids to navigation. In particular, this part provides that the International Convention on Regulations for the Prevention of Collisions at Sea, 1972, also known as the Collision Convention, has the force of law in the islands. As such, Mr. Speaker, all vessels shall comply with the Collision Convention unless exempted by the Chief Executive Officer of the Maritime Authority. Further, under this part, there are duties imposed on the master of a ship, including a duty to render assistance following a collision, a duty to assist a ship in distress, a duty to assist persons in danger at sea, a duty to report any accidents at sea, and a duty to notify of any dangers or hazards to navigation. Mr. Speaker, this part also includes for the establishment and management of aids of navigation, which are lighthouses, buoys, beacons, radio aids, or any other light signal or marked established to aid marine navigation, and includes all buildings and other works associated therewith. Mr. Speaker, Part 7 contains clauses 156 to 188, provides for the safety of life at sea and maritime safety. It enshrines the International Convention for the Safety of Life at Sea, 1974, known as the Safety Convention, as law in the Cayman Islands. As such, prescribes vessels shall comply with the Safety Convention unless exempted by the Chief Executive Officer of the Maritime Authority. This part further requires that inspections and surveys of ships shall be carried out by a surveyor or inspector to determine whether the ship is in compliance with the Safety Convention. Surveyors' duties and responsibilities are further amended to reflect clearly the requirements of this convention. Part 8, Mr. Speaker, which sets out clauses 189 to 203, provides for matters related to the safety of a submersible craft. This part, Mr. Speaker, provides that an owner of every submersible craft to which this part applies must be registered under the Register of Submersible Craft and have a safety certificate. As it relates to the construction and equipment, Mr. Speaker, of a submersible craft, this part empowers the Cabinet to make regulations which, among other things, specify construction requirements and supporting apparatus, requires a submersible craft and supporting apparatus to be surveyed, and provides for the making of declarations of a survey. Also prescribes obligations which any person concerned with the operation of a submersible craft and supporting apparatus must fulfill, and the required qualifications which such a person must hold, and provides for the detention of any submersible craft or supporting apparatus in respect of which a contravention of the regulation has or is suspected to have occurred. This part also provides for the issue, duration, extension, suspension, and revocation of safety certificates in respect of a submersible craft. Furthermore, Mr. Speaker, it provides for inquiries and investigations into casualties which occur in respect of a submersible craft or supporting apparatus. As it relates to offenses, a person who causes or permits to cause or is otherwise concerned with the launch, recovery, operation, or support of a submersible craft in contravention of the legislation commits an offense and may be subject to a fine. Mr. Speaker, Part 9, which sets out clauses 204 to 231, speaks to load lines, which are the lines marked on a ship that indicate the maximum depth to which a ship may be loaded. It provides that the International Convention on Load Lines 1966 and its annexes as modified by the 1988 Protocol and as amended and modified or replaced from time to time as extended to the Cayman Islands. That mouthful, Mr. Speaker, is the 1966 Convention. It confirms in the legislation, in the bill, that this will have the force of law. As such, prescribed vessels shall comply with the 1966 Convention unless exempted by the Chief Executive Officer of the Maritime Authority. This has led to a significant amount of clarification. The new structure closely follows the recent published UK legislation to implement the 1966 Convention by reference. Part 10, Mr. Speaker, which sets out clauses 232 to 241, provides for the carriage of grain and other bulk cargoes, the carriage of dangerous cargoes, and the making of regulations in relation to such cargoes. Unless expressly provided otherwise, this part applies to all ships to which the Safety Convention applies and to cargo ships of less than 500 gross tons. Mr. Speaker, Part 11, which contains clauses 242 246, provides for unsafe ships and matters related to such ships. This part provides that the Chief Executive Officer has the power to detain unsafe ships. It also provides that the owner and master are liable in respect of an unsafe ship, and further, that it is an offense to have a Cayman Island ship or to have a ship in port of these islands if it's in dangerously unsafe condition. This part also provides that it is the duty of the owner of a ship to take all reasonable steps to ensure that the ship is operated in a safe manner, Mr. Speaker. Part 12 sets out clauses 247 to 302, deals with wrecks and salvage and related matters. This part, Mr. Speaker, is amended to refer to the International Convention on Salvage 1989 directly and gives the convention the force of law in the Cayman Islands as amended, modified, or replaced from time to time, and is extended to these islands. It should be noted, however, that certain provisions under this part do not apply to the following structures and vessels. A fixed or floating platforms, or to mobile offshore drilling units when such platforms or units are on location engaged in exploration, exploitation, or production of seabed mineral resources. And, Mr. Speaker, warships or other non-commercial vessels owned or operated by a foreign state and entitled, at the time of salvage operations, to sovereign immunity under generally recognized principles of international law, unless the state has decided to apply the Salvage Convention to such ships or vessels. Therefore, Mr. Speaker, it is expected that the Wreck and Salvage Law 1996 can be repealed as a result of these updates in this bill. Mr. Speaker, Part 13 sets out clauses 303 to 310, provides for the control of persons on ships, passenger returns, the returns of births, and deaths on ships. This part provides for the master's power of arrest and provides for a person who is arrested under the master's power of arrest may approach the shipping master to consider if the arrest was appropriate. Finally, this part clarifies and updates procedures in relation to births and deaths occurring on a ship. Mr. Speaker, Part 14 sets out clauses 311 to 405, which I believe is the largest portion of the bill, provides for the liability and compensation, and is an amalgamation of two separate parts in the existing act, which are proposed for repeal and are governed by the liability and compensation in provisions from the previous legislation. This part provides that the Athens Convention, the Bunkers Convention, the Fund Convention, the Limitation of Liability Convention, the Liability Convention, and the Wreck Removal Convention have the force of law in these islands in relation to Cayman Islands ships. Accordingly, Mr. Speaker, Part 14 sets out these extensive provisions related to all of the said conventions and their protocols. It also provides for regulations to be made, to be given to those protocols to have the force of law as they may be extended to these islands, which includes the Athens Protocol 2002, the Fund Protocol of 2003, and the HNS Protocol of 2010. Part 14 has also been updated to refer to various conventions directly. This has led to significant streamlining and clarity, in particular regarding oil pollution liability, which were previously all contained in a single chapter, which was not always the easiest to follow or interpret for policymakers and, importantly, Mr. Speaker, for ship owners to follow. Part 15, which sets out clauses 406 to 413, has been significantly updated recent changes in terminology, including the definition of armed robbery, and to reflect the UN Convention on the Law of Sea of 1982. For clarity, Mr. Speaker, this part splits up offenses into piracy, armed robbery, hijacking of ships, seizing or exercising control of fixed platforms, the destruction of ships or fixed platforms or endangering the safety of such ships or platforms, and any other act endangering or likely to endanger safe navigation. The master of a ship no longer has the power of delivery. This refers to where previously the master had reason to suspect anyone had committed or attempted to commit an offense under this part, or aided the commission of an offense, then the master could arrest and deliver the person to the police in the island or in another country under the UN Convention of the Law of the Seas. Mr. Speaker, Part 16, which sets out clauses 414 to 425, has been revised considerably to clarify the powers of the various enforcement officers, surveyors, inspectors, and accident investigators appointed under this part. This part now ensures clarity and compliance with the Cayman Islands Constitution, in particular regarding surveyors, to make it clear that they must be appointed to act as an inspector. Specific reference is made to the powers of inspectors as per the Bill of Rights in our Constitution, Mr. Speaker. Both surveyors and inspectors are appointed by the Chief Executive Officer of the Maritime Authority and may be appointed either generally or in a particular case or particular purpose. Marine accident investigators are appointed and report to the Minister, which is an important distinction to ensure that investigations are impartial and objective. Based on long experience that the Maritime Authority has held, this part provides considerable changes to the procedures for the issuance of improvement and prohibition notices and for detaining of ships, which has been included in this section after previously being multiple parts elsewhere in the existing legislation. There is also a much more developed process for complaints and about actions including detailed arbitration and compensation provisions. This part also provides, Mr. Speaker, that questions related to reasons or matters specified in an improvement notice, a prohibition notice, or a detention order shall, if a person on whom a notice was served or the owner of a detained ship so requires, be referred to a single arbitrator appointed by agreement between the parties for that question to be decided by the arbitrator. Mr. Speaker, Part 17, which sets out clauses 426 to 430, provides for the investigations into marine and shipping casualties. This section now reflects recent changes in terminology, in particular to reflect the Merchant Shipping Marine Casualty Reporting and Investigation Regulations 2018 and the IMO Casualty Investigation Code. Mr. Speaker, this section on death inquiries now reflects the practical experience and the modern terminology that suits this area of the maritime law. Part 18, Mr. Speaker, sets out clauses 431 to 445, deals with legal proceedings and related matters, including the prosecution of offenses related to a jurisdiction, the enforcement of the detention of a ship, and special evidentiary provisions. In this part, minor changes have been made to reflect modern procedures or where addressed elsewhere in Cayman Islands legislation. As such, the verbiage around offenses committed by seafarers on Cayman Island ships now reflects current laws and processes, in particular our penal code. There is also further clarification on the rights of non-Cayman Islands ships when transiting our waters. This means that a ship which is traveling between ports not in the islands but passes through the territorial waters has the right to travel unimpeded by Cayman Islands authorities unless there's a suspicion of breaching our laws. Finally, Mr. Speaker, Part 19, which sets out clauses 446 to 466, has been updated to reflect modern administrative procedures and processes. It clarifies the specific role of the responsible minister and the chief executive officer of the Maritime Authority. As it relates to the administration of the legislation, the minister with responsibility for merchant shipping and seafarers has the general superintendence of all matters related to merchant shipping and seafarers and is authorized to carry out the execution of the provisions of this and all legislation relating to merchant shipping and seafarers, except where those provisions concern revenue. That belongs to the Port Authority and the Director of Ports. Where the provision of legislation concerns revenue, it will obviously, as all of the rest of our revenue, be administered by the Minister of Finance, and the Minister with responsibility for the Port Authority will administer provisions under the legislation concerning the matters that relate to the Port Authority and the Director of Ports. Mr. Speaker, this part also deals with miscellaneous supplementary matters, including matters related to the administration of the legislation, general regulation-making powers, the making of shipping notices, the application of the Act, certain descriptions of ships, the repeal of the existing Merchant Shipping Act 2021 revision, and the Wreck and Salvage Act 1996 revision, and, Mr. Speaker, the application of UK law as appropriate. It further updates the general regulation-making power to better reflect how this should be utilized and changes made elsewhere in this new bill. In addition, Mr. Speaker, there's also a new provision on the Chief Executive Officer's discretionary powers, where an international agreement is extended by the UK requiring a determination to be made. Mr. Speaker, this also provides for the reg-making power to prescribe fees to be charged under the legislation. Further, it provides that certain expenses shall be payable out of the monies provided by this Parliament. This includes expenses incurred by the receiver of a wreck, and such expenses as the Cabinet directs for establishing and maintaining on the coast of the islands proper lifeboats with the necessary crews and equipment and affording assistance towards the preservation of life and property in the cases of a shipwreck or distress at sea. The Cabinet is also empowered, Mr. Speaker, under this part to make regulations as it considers appropriate arising out of matters in this legislation or to give effect to any of the provisions of an international agreement relating to merchant shipping or seafarers adopted by the United Kingdom and as extended to these islands. Further, this part provides for the application to non-Cayman ships, government ships, ships chartered by demise, to the government, and to certain structures. As it relates, Mr. Speaker, to the application of UK legislation, this part provides the Cabinet may, after consultation with the Secretary of State for Transport of the United Kingdom, by order, apply to the islands as part of the law of these islands, subject to such exceptions, adaptations, and modifications as may be specified in the order, and any legislation of the UK to which this section applies. It should also be noted that any regulations made under this legislation shall be made after notification of the regulation is given to the Secretary of State for Transport of the UK. There's also one schedule at the back which deals with the instruments and documents for which forms are be prescribed. Mr. Speaker, as I've said a mouthful, I will take this opportunity to pause, and any gratitude to staff and other votes of thanks I'll deal with by exercising my right of reply. Thank you, Mr. Speaker. I now commend the Merchant Shipping Bill 2023 to this Honorable House for its third reading.
Thank you, Minister. Does any other member wish to speak? The Honourable Leader of the Opposition.
Thank you very much. Thank you very much, Mr. Speaker. Mr. Speaker, I rise very simply to indicate that the official opposition support this bill in its entirety. We understand and know that this is really a repeal and a replacement of what has been a an act or law that has existed for some time. It is clear, and from my own discussions with people in industry, that a lot of time and effort has gone into updating and revising the legislation. It is an area in which none of us really have any real experience with, or knowledge and understanding of the operation of the merchant shipping and all aspects of its operation. So my comments are just limited, Mr. Speaker, to just confirming that we will support the bill. And I thank the member for his introduction of it and for his explanation of the various sections of it. Thank you.
Thank you, Mr. Leader. Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I will invite the Minister to exercise his right of reply.
Thank you, Mr. Speaker. I'd like to thank the opposition, the official opposition, for supporting the legislation. I think the leader of the opposition indicated that it is exciting for those who practice in this industry. They've been waiting for this for quite some time. It also potentially provides new avenues of business for the Maritime Authority that they're quite excited to try to capture and attract to the Cayman Islands and add more ships to the shipping register. It, as I said from the outset, Mr. Speaker, is a very large bill. There are lots of people to thank, including all of the ministry staff, all of legal drafting, in particular the formidable Ms. Cheryl Neblett, first legislative counsel, who painstakingly went through the bill. As usual, with a bill this large, there would be clauses that would go some bit of back and forth and to-ing and fro-ing, and she handled it expertly. In addition, there are a few key staff in the Maritime Authority, Mr. Angus McLean and Mr. James Hatcher, who are just experts in their field and could break down in extraordinary detail the history of the provisions, the future trends for the maritime sector, and to be able to bring this to fruition, to leave the outstanding item on the IIICO audit now, if passed by this House, Honorable House, ticked. And of course, the incredible ministry staff, led in this particular case by the Deputy Chief Officer of the ministry, Ms. Catherine Dinswell-Powell. Their support and guidance to drive this to presentation in this House has been incredible, and I immensely thank them. The Maritime Authority as a whole is wonderfully led by Mr. Joel Walton, a recent recipient on Heroes Day for his efforts in this area. They've really taken a small shipping registry and made it a global powerhouse in which 60%, 60, of the world's yacht registrations are on Cayman Islands shipping register. And the register has celebrated its 120th anniversary, which is extraordinary. So I'd like to thank Mr. Walton and all of his staff and all of the wider staff that helped with the III audit, because this legislation would have only gotten so far, even if it was completed, with all the other work that had to be done in the audit. And DG, I think a special mention goes to the Cabinet Secretary, who I think led the working group and moved this process through the audit as smoothly as he could, and the single point of contact, who was Ms. Tanya Mortimer of the Maritime Authority, really deserve a special mention. Lastly, Mr. Speaker, there is as I indicated previously, a historical link to the Cayman Islands and this legislation. I think all of us can picture the purpose of the Seafarers Association, the Seafarers Hall. And if you remember, one of the purposes is to have young Caymanians pursue a career in maritime-related field. You can think of no other way at the moment that we can assist in that able goal than to expand legislation, provide opportunities around the world for our Caymanians. The Maritime Authority, I think, has 39 employees, 60% of which, or nearly 60% of which are Caymanian. If this now opens up new avenues and new opportunities for our Caymanians to participate in an area that carried the country for such a historic amount of time, this is a way to, in part, repay that debt. So with that, Mr. Speaker, I conclude my right of reply and commend the bill passage in the House.
Thank you, Minister. The question is that a bill shortly entitled the Merchant Shipping Act 2023 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I think the ayes have it. The bill has been set down for a third reading. Before we move on to the next bill, I was reminded by having received from the Honorable Minister who just spoke a notice of committee stage amendment, a quite appropriate one. I say that because of what I will now say. I am conscious that 6 of the 8 ministers here are ministers for the first time. And so there are some things that you just don't automatically know. This is one of my second meeting in the chair as speaker. But at the last meeting, there was a bill. I'm not trying to put blame on anyone, so I'm not going to say which bill it was or which minister it was. But there was a bill, a very important bill, which had so many committee stage amendments and such and so many and so comprehensive in nature amendments that they combined fundamentally altered the bill. The importance of that is that Section 77 of our Constitution requires that all bills be published in a government notice at least 28 days before the bill is introduced to the House. And the purpose of that is to give a minimum period of consultation and opportunity to the broader populace to consider what is being proposed. If then, when we come here and the bill gets referred to the committee, the fundaments of that bill are so altered in nature that they bear little relation to what the public has had the opportunity to consider. We are really not operating in a proper, transparent, and democratic matter as a parliament. And if you look at the standing orders themselves, you will see that you will see if you have regard to standing order 49.1, right, committal of bills when a bill has been read a second time, it shall stand committed to a committee of the whole House, which is what we've just done, unless the House on motion made refers it to a select committee, which is not the case here. But that's how the process is initiated. The function of a committee on bills, that's Standing Order 51. A committee to which a bill is referred shall not discuss its general merits and principles, but only its details. So it is clear from that, or the inference to be drawn from that, is that that discussion about the principles of the bill, the policies which underpin it, is to occur during the second reading debate. Members will have no opportunity to debate in a broad and general way changes that are proposed at the committee stage level. And I just referred to the notice period, section Standing Order 52.2, notice of any amendment, new clause, or new schedule proposed to be moved to the bill shall be given in writing not later than 2 days before that on which the bill is to be considered in committee. And except with the leave of the chairperson, no amendment of which notice has not been given may be moved. In practice, because of the way we have to get things done, often that notice period is waived because the minister hasn't had an opportunity to get the notice to the speaker in time. Every amendment shall be relevant to the subject matter of the clause to which it relates. The chairperson may refuse to put an amendment which appears to the chairperson to be intended to vary the basic substance of a clause, if in the chairperson's opinion the proper course is to negative the clause and propose a new one. So I am appealing to ministers to make my life easy. You know I like to be a nice person all the time. But I have to do my duty under the Constitution to ensure that the process for the introduction and passage of legislation in this House is in accordance with what the tenets of the Constitution require. So if I had been in the chair, a bit longer, having reflected and actually spoken with the Attorney General about what transpired at the last meeting, I would have said to the minister, quietly, I hope, you need to go start over. If what you are proposing, if what you proposed is so different from where you end up when you come here, you need to go draft another bill and you need to publish it again so that the consultation process can start over. So I have no indication that that's going to happen this time, but having just received the notice of an amendment from the minister, the Deputy Premier who just spoke, it reminded me of my concerns about that. But Minister, Deputy Premier, your amendment is perfectly fine. I have no issues with that. But it just reminded me about this. Madam Clerk.
Local Companies Control Amendment Bill 2023.
The Honourable Deputy Premier.
Thank you, Mr. Speaker. I beg to move the second reading of a bill entitled the Local Companies Control Amendment Bill 2023.
The bill is duly moved. Would the Honourable Deputy Premier wish to speak thereto?
Yes, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It is a bill that seeks to amend the Local Companies Control Act 2019 revision, which referred to hereinafter as the Principal Act, to remove the prescription of fees from the Principal Act and to provide for this and other related matters to be addressed in subsidiary legislation through regulations passed by Cabinet. Mr. Speaker, the Local Companies Control Act, the existing Principal Act, provides a legal framework for local resident companies to execute business in the Cayman Islands. Section 51 of the Act states that the requirements with which these companies are required to comply are as follows. Be Caymanian controlled. At least 60% of the shares are beneficially owned by Caymanians, and at least 60% of its directors are Caymanian. Notwithstanding this, the Act makes provision for companies that do not comply with these requirements to apply to the Trade and Business License Board for a license. Such license is subject to the fulfillment of other specific requirements in the legislation. Where an application, Mr. Speaker, is submitted, Section 10 of the Act provides that the application is to be accompanied by a processing fee of $200 CI, Cayman Islands dollars, and a license fee, annual fee of 2,500 Cayman Islands dollars. Where the license is granted, Section 13.1 provides for the payment of said $2,500 on an annual basis based on the anniversary date on which the initial license was granted. Mr. Speaker, the fees for said licenses, commonly referred to as LCCLs, has not been revised for 17 years. There is no doubt, Mr. Speaker, that companies doing business in the Cayman Islands have experienced many changes over the last 2 decades, whether it's the type of activities they undertake, the complexity involved, technological advances, changes in operational cost, or regulatory requirements. Against that background of our evolving economy with greater local expertise, which have significantly developed over time, the Trade and Business License Board must continue to review license applications for legislative compliance, which is getting more and more rigorous. Mr. Speaker, the practice of prescribing fees only in the Principal Act stands in contrast to the country's modern legislative convention where fees are prescribed in regulations. Mr. Speaker, the fact that the existing Principal Act contains the historical convention of including fees in primary legislation is further evidence of the length of time since this legislation has been examined and enhanced. Mr. Speaker, the modern legislative convention of permitting the executive to set fees has the clear benefit to make efficient adjustments as to policy, budgetary concerns, market forces, and operational demands. Accordingly, Mr. Speaker, the intention of the amendment presented today is to remove the direct references to fees from the Principal Act and instead insert a provision that gives Cabinet the power to prescribe in regulations all matters that are required or permitted to be prescribed under the Act, including fees. As this is evident that the wider regulation-making power goes beyond just the prescription of fees, it relates to matters similar to other legislation, as painfully described in the last bill in relation to merchant shipping, for other administrative processes that fall under the Act and in the hands of the Department. Thus, Mr. Speaker, this allows for more effective administration of commerce policy and swifter capability to respond to changing circumstances now and in the future. The policy of our government is to encourage commercial enterprise by fostering a business environment that enables the private sector to flourish. Mr. Speaker, we welcome businesses that seek to enhance the development of the Cayman Islands and its people. The Local Companies Control License allows companies to conduct business in the Cayman Islands that would not ordinarily be able to do so. However, it's worth noting, Mr. Speaker, that as at December 2023, there are approximately 217 licensees on record. So, Mr. Speaker, there's another policy ground for making this change. The fact of the matter is, not only does the government consider the current fee structure woefully inadequate, but there are also important policy considerations. Because, Mr. Speaker, the irrefutable fact is that there are Caymanians who, for quite some time now, have either the experience and/or the qualifications and/or the capital, either on an individual basis or as a group, to conduct a wide variety of businesses that were not necessarily, we as a people were in a position to do so decades gone by. So, Mr. Speaker, if it is truly the case that a proposed business is deemed fit to be exempt from having at least 60% Caymanian directorship and ownership, beneficial ownership, in this day and age, then it is the view of the government that there should be a far heavier price to pay on policy grounds to have someone have a license for a business that's exempt from the 60-40 Caymanian rule. The Commerce Ministry also takes this opportunity to review processes for LCCLs and to make modifications to reflect current reality. As such, Mr. Speaker, the Commerce Ministry has been instructed to commence public consultation with stakeholders to get their initial feedback, to aid caucus and onward to Cabinet in determining the revised final fee structure and any application processes that are ripe for adjustment. Mr. Speaker, the bill is arranged in 5 clauses. Clause 1 has the usual short title, Commencement. Clause 2 provides for the amendment of Section 10.2 by the deletion of the words a processing fee of $200, a license fee of $2,500, and substituting it with the prescribed fees for the processing of the application and for the license. Clause 3 provides for an amendment to Section 11, which deletes the reference to the fee prescribed in Section 13 and replaces it with the prescribed annual license fee referred to in Section 13. This is consistent with the fees now being prescribed in regulations and other legislation. Clause 5, Mr. Speaker, provides for the amendment of Section 13.1, which deletes the words referring to a specific fee, a fee of $2,500, and replaces it with the words the prescribed annual fees, similarly consistent with regulations in other areas of our statute book. Clause 5 provides for the amendment of Section 22, which addresses the regulation-making power of Cabinet and expands it by specifically giving, Mr. Speaker, the Cabinet the power to prescribe all matters that are required or permitted to be prescribed under the Act, including fees. The power, Mr. Speaker, for Cabinet to prescribe fees and regulations was not specifically stated in the current Act, given that they weren't in place when the Act was initially enacted. Moving the fees to regulations now require these amendments to be made to establish the link between the two and giving Cabinet the power to make these regulations. Mr. Speaker, this concludes my presentation of the proposed bill. In closing, I wish to thank the Ministry's staff, the Legislative Drafting Department for their efforts with respect to the development and preparation of the bill, and the ongoing efforts of the Ministry staff to have consultation appropriate so fees are set in a way that are suitable for our current framework. I therefore commend the Local Companies Control Amendment Bill 2023 for this Honorable House for its second reading.
Thank you, Honorable Deputy Premier. Does any other member wish to speak? The Honorable Leader of the Opposition.
I forgive you, sir.
You looked at him, so I was wondering.
Thank you very much, Mr. Speaker. Mr. Speaker, very simple bill here before us this afternoon in the Local Companies Control Amendment Bill 2023. Understand that the fees that are spelled out in the law will be repealed or changed, and it will give Cabinet the ability to set the fees going forward. From the opposition side, we don't have any problems with the bill as it drafted and what is being contemplated. So I would voice once again our support for the bill that's before the House at this time. Thank you, Mr. Chairman, Mr. Speaker.
Thank you, Honorable Leader of the Opposition. Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honorable Deputy Premier to exercise his right of reply.
Thank you, Mr. Speaker. Very briefly, just to thank the official opposition for their support of this relatively simple amendment bill, and to thank my colleagues in caucus and cabinet for supporting it to this date. Thank you.
Thank you, Honorable Deputy Premier. The question is that a bill shortly entitled the Local Companies Control Amendment Bill 2023 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. The Local Companies Control Amendment Bill 2023 is set down for third reading.
Companies Amendment Bill 2024.
The Honorable Deputy Premier.
Thank you again, Mr. Speaker. I beg to move the second reading of a bill entitled the Companies Amendment Bill 2024.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, thank you, Mr. Speaker. Mr. Speaker, I rise on behalf of the government to present the bill to amend the Companies Act to provide commercial, private sector suggested amendments to this important financial services legislation. To provide new modifications and innovations which relate to how you vary the procedure for varying share capital, to provide for the repurchase and redemption of fractional shares, and to provide for the conversion of a limited liability company or a foundation company to an exempted company, and for an exempted company to re-register as an ordinary resident company and other connected purposes. Mr. Speaker, in line with the government's strategic broad outcome of enhancing the competitiveness while meeting international standards, the bill is aimed to maintain our best-in-class financial services. It is critical, Mr. Speaker, that the Companies Act is continually enhanced for the Cayman Islands to maintain a competitive advantage in the international market and to ensure that the Act functions for the benefit of legal practitioners and their clients and related stakeholders alike. The bill was resulting from proposed amendments that were considered advantageous to the country by the Financial Services Legislative Committee and its Company Act Subcommittee. The Financial Services Legislative Committee is still chaired by the very able, though retired, Charles Jennings, and the subcommittees are made up of current practicing practitioners. Mr. Speaker, the proposals that were subject to extensive legislative process by the Ministry of Financial Services and Commerce, and included stakeholders beyond the Financial Services Legislative Committee and its subcommittee, and went out to industry-wide consultation because we valued the entire industry's input. Mr. Speaker, I will now summarize the key amendments in the bill. As it relates to the reduction of share capital, Mr. Speaker, under English common law, which the Cayman Islands legal system is of course based, capital maintenance rules require that share capital of a company be preserved. This stems from a cardinal principle that the share capital of a company belongs to a company and not to its shareholders. It provides protection to the company's creditors, and the company's capital may not be returned to its shareholders except under procedures which safeguard the interests of creditors. Our adherence to these principles in our law is one of the structural reasons why Cayman Islands remains so popular in financial markets. In practice, however, Mr. Speaker, there are reasons why a company may need or wish to reduce the amount of its share capital, including as a means of returning surplus capital to shareholders, to buy back or redeem its own shares, or to create distributable reserves to pay a dividend. In our company's regime, Mr. Speaker, the only way to effect a reduction of capital is required by confirmation by the court. Seeking court approval for a capital reduction of a solvent company, a company which has sufficient assets to meet its liabilities, it's unnecessarily expensive and impractical to go to court each time. In such circumstances, creditor protection is not required. This bill introduces the option of capital reduction without the need for court approval in certain circumstances where it's a solvent company. Mr. Speaker, where authorized by the company's Articles of Association, a company will be able to reduce its capital by special resolution supported by a solvency statement. Mr. Speaker, a solvency statement is defined in the bill with the meaning that a full inquiry into the company's affairs has been made, and to the best of the director's knowledge and belief, the company will be able to pay its debts as they fall due in the ordinary course of business from the date of the statement. Where the reduction of capital is supported by a solvency statement, the bill requires the company to deliver to the registrar of companies a copy of the solvency statement and the minute showing specified information within 15 days of the passing of the special resolution. Upon receipt, Mr. Speaker, of the copy of the solvency statement and the minute, the registrar shall register them. On registration by the registrar, but not earlier, the special resolution for the reduction of capital shall take effect. As it relates, Mr. Speaker, to conversions and re-registration, Mr. Speaker, conversions are intended to afford flexibility to persons who have established Cayman Island structures to deal with changes in circumstances. Conversions may be useful in many instances, including providing a procedure to facilitate initial public offerings. They do not create a new legal person, so they do not affect the continuity of the converting entity or its property. Additionally, appointments made and resolutions passed will not be affected, nor will any legal proceedings be conducted by or against the entity be rendered defective. Mr. Speaker, the bill will also permit the conversion of a limited liability company, known informally as an LLC, or a foundation company to an exempted company. Additionally, the bill will also permit an exempted company to re-register as an ordinary resident company. Presently, Mr. Speaker, the Principal Act permits an ordinary non-resident company, which is a company which does not or has no intention of carrying on business within the islands, to re-register as an exempted company. However, we don't have the reverse, where an exempted company which was primarily conducting its business outside of the Cayman Islands to be able to re-register as an ordinary company if it wants to move a substantial part of its business to the island. Mr. Speaker, you will be familiar with the economic substance rules that came in by way of the OECD and the EU years ago. In an interesting turn, it has now provided the opportunity where businesses are bringing substantial presence to the islands and having a more significant footprint here. This is now attracting very sound businesses to the island. It's providing economic growth, local job opportunities, educational opportunities, and boosting the global reputation. As such, the bill seeks to make it efficient to re-register as an exempted company by operation of law, rather than a tedious, unnecessary process where you would have to transfer the assets of an existing exempted company, move it over to a newly formed ordinary resident company, then liquidate the exempted company. All of this now would happen by operation of law. Makes it neat and efficient. And if the exempted company, now having a more substantial presence in the island, then falls within the remit of the local company's regime, just like any other ordinary resident company, it'll have to comply with the relevant regulations and legislations as they relate to ordinary resident companies. Mr. Speaker, the bill is arranged into 20 clauses. Clause 1 provides for the short title and commencement of the legislation. Mr. Speaker, Clause 2 provides for the general amendments to the Principal Act to remove the use of Roman numerals in part headings. Clause 3, Mr. Speaker, provides for the insertion of new definitions into the Principal Act, including the definitions of high net worth person, solvency statement, and sophisticated person. Mr. Speaker, Clause 4 provides for the amendments to Section 14 of the Principal Act to, among other things, permit companies limited by shares or guarantee to reduce their share capital by special resolution supported by a solvency statement. The clause also provides for the amendment of Section 14 to refer to a special resolution as a special resolution for reducing share capital. Mr. Speaker, Clause 5 provides for the insertion of Sections 14A and 14B into the Principal Act. The new Section 14A provides for the reduction of share capital, which is supported by the solvency statement. The new Section 14B provides the procedure for registration where both the solvency statement and the minute of reduction are delivered to the registrar within 15 days after a special resolution for reducing share capital is passed, and where the solvency statement and the minute of reduction are registered, the registrar shall publish this in the Gazette. Mr. Speaker, clauses 6 and 7 provide for the amendment of Section 15.1 and Section 16.2 of the Principal Act, respectively, to refer to the resolutions of reducing share capital as a special resolution for reducing share capital. Mr. Speaker, Clause 8 provides for the amendment of Section 37 of the Principal Act to empower companies limited by shares or limited by guarantee, if authorized to do so by their articles of association, to issue fractions of shares. Clause 9 provides for the amendment of the meaning of the words special resolution in Section 60 of the Principal Act. I'll come back to that in a moment because it relates to the committee stage amendment you made reference to before this presentation. Mr. Speaker, Clause 10 provides for the repeal and substitution of Section 88.1 of the Principal Act and the insertion of a new subsection 1A in Section 88 of the Principal Act. The amendments are to clarify that shares held by the transferee company or its nominees or subsidiaries are not to be included in the calculation of 90% in value of the shares for which an offer has been made. The insertion provides for the transfer of shares from shareholders to the transferee company. Mr. Speaker, Clause 11 provides for the amendment of Section 201 of the Principal Act to enable bodies corporate with or without a share capital under the laws of any jurisdiction outside the Cayman Islands to apply to register by way of continuation as an exempted company limited by shares under the Principal Act. Clause 12 provides for the deletion and substitution of the part headed Part 13. Mr. Speaker, Clause 13 provides for the insertion of sections 211A and 211B in the Principal Act. The new section 211A provides for the re-registration of an exempted company as an ordinary resident company where the company passes a special resolution in support of the re-registration and an application for re-registration to be delivered to the registrar together with the necessary documents and fee. The new section 211B sets out the effects that follow where when an exempted company is re-registered as an ordinary resident company. The new section 211B provides that the issue of a certificate of re-registration shall not operate to create a new legal entity, Mr. Speaker, affect the property of the company, affect any appointment made or any resolution passed, nor does it affect the rights, powers, liabilities, or obligations of the company. Mr. Speaker, the section also provides that the issue of a certificate of re-registration shall not operate in such a manner as to render defective any legal proceedings by or against the company. Clause 14, Mr. Speaker, provides for the deletion and substitution of the part of the heading for Part 16. Clause 15, Mr. Speaker, for the amendment of Section 232 of the Principal Act by the insertion of the definitions for the words foundation company and LLC agreement. Mr. Speaker, Clause 16 provides for the amendment of Section 233 of the Principal Act, which deals with mergers and consolidations. The new subsection 13 in Section 233 provides for the determination of the effective date of a merger or a consolidation. Mr. Speaker, Clause 17 provides for the insertion of Sections 233A and 233B. The new Sections 233A provides for the conversion of a limited liability company to an exempted company. The new Section 233B provides for the conversion of a foundation company to an exempted company. Clause 18, Mr. Speaker, provides for the variation of the procedure under Section 238 of the Principal Act for exercising a member's entitlement to payment of fair value for shares where that member dissents from a merger or consolidation. Within 20 days immediately following the date of the authorization, the constituent company is required to give written notice of the authorization received for the plan of merger or consolidation to each dissenting member who made a written objection within the objection deadline. Mr. Speaker, Clause 19 provides for the amendment of Section 239 of the Principal Act as a consequence of the amendment of Section 238 to introduce the objection deadline. As such, the amendment provides that the rights relating to the dissenters under Section 238 shall not be available on the expiry of the objection deadline. Clause 20, Mr. Speaker, finally provides for the amendment of Section 252(5) by the repeal of the definitions of the words ordinary resident company and ordinary non-resident company and ordinary resident company, as the definitions are proposed to be inserted in Section 2 of the Principal Act by virtue of the amendments contained in Clause 3 of the legislation. Mr. Speaker, that provides an overview of the arrangement of clauses. The purpose of the clauses is the bill was published. But after publication of the bill, to which is the committee stage amendment to which you referred, there were firms within, actually I should put it another way, there were teams within firms that I think have a practice area that represent more minority shareholders. So they asked for additional time for the Financial Services Legislative Committee to delete Section 9, which relates to allowing a special resolution to be passed not unanimously in writing, but by 2/3 in writing. They thought that that might be too onerous on the minority investor. So there will be notice of a committee stage amendment to delete that to revert to the existing status quo in the legislation where special resolutions can only be passed unanimously if they're done in writing, unless there's a meeting, and then who turns up to make the 2/3 turns up. So from the Ministry of Financial Services perspective, we saw no difficulty that if the industry would like a bit more time to contemplate it for sort of narrow practice areas, we have no difficulty because this entire bill is driven by their desire for enhancements and innovations. So there'll be a small amendment to delete that section, and then there's a couple of consequential amendments that flows into in the bill to delete a couple more clauses, or at least 3 more clauses. With that, to provide the opposition with any opportunity they have on those questions and can have, if they want further elucidation on the committee stage amendments, I'm happy to take questions and answer them in exercising my right of reply.
Honorable Deputy Premier, before you resume your seat, you referred to Section 9. I presume you meant Clause 9.
Clause 9, yes, sir.
Thank you. Does any other member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I thank the Minister for his able presentation on the bill and the purpose of it. I rise too on behalf of the opposition to indicate our support for the legislation and for the amendments to the bill. Mr. Speaker, I spoke with the Minister last week about the bill because I had actually received representations from a couple of people who were in the financial services industry who did not fully understand, I believe, the clauses and what the bill was attempting to achieve. And there was some concern expressed to me with regard to the ability of a exempted company to be able to convert to and re-register as an ordinary resident company. And Mr. Speaker, I sat down with the Minister and his team in the Ministry of Financial Services and talked through the issues that were there. And I fully understand and appreciated what it was they were trying to achieve. And personally, I don't see any issue whatsoever with what the concern that was being expressed in limited places in industry where it was. I had received representations and I had communicated that to those that had expressed it to me. And I think once I explained it, they were grateful for it. And I think they were concerned that an exempted company in converting to an ordinary resident company was going to be gaining some advantages that they would not normally have. And when I explained them what the process is of re-registering, that all of the benefits and all of the rights that they would enjoy as an exempted company would cease to exist, and they would then have to acquire all the rights and obligations of an ordinary resident company. It made perfect sense to them. So I think, Mr. Speaker, not really much that I can add to the debate here today, but just let the Minister know that we fully support the bill.
Thank you, Honorable Leader. Does any other member wish to speak? The Honorable Member from 4 Newlands.
Thank you very much, Mr. Speaker, and I too would like to join with the Honourable Leader of the Opposition in commending the Deputy Premier for his able presentation on the Companies Amendment Bill. I have to say, Mr. Speaker, that the issue which the Leader of the Opposition just spoke to in terms of a conversion from an exempted company to an ordinary resident company, was one that I had questions put to me as well. And of course, I explained, as has been noted, that this doesn't mean that an exempt company is going to be able to get some kind of special advantage by converting like that. They have to comply with all of the requirements. And shareholders in that company, in a scenario like that, converting to an exempt company would have additional obligations. The company would have additional obligations in ensuring that it is able to do business. I did think that I was going to have to slightly bemoan some of the changes, particularly, and the leader, sorry, the deputy premier will probably understand where I'm coming from. The proposed changes to the definition of a special resolution. But having seen the amendments that are proposed, obviously that takes that issue away, at least for the time being. I can't say that I had a strictly principled position in respect of it, but there were just some concerns because it's one of those things that you understand that, you know, a special resolution is a resolution that can change many significant things in a company, and having the right to attend a meeting, having notice to attend a meeting, and to be able to participate is an essential sort of reflection of the rights of shareholders to have their voice heard. So it is, I have to say, somewhat of a relief to see that there is a proposed further review of that. Mr. Speaker, the work of the Financial Services Legislative Subcommittee is, as the Deputy Premier noted, to be commended. Over the years, they have done really good work in ensuring that the Cayman Islands laws in the financial services area are leading edge, up to date at least, but mostly leading edge as well, by working with many of the leading practitioners in the onshore centers that we serve and we deal with. So certainly they deserve our support, and I agree with the Deputy Premier in noting the value that they contribute. Mr. Speaker, with those few words, I will say thank you, and I look forward to the further contributions from the Deputy Premier as we move through the consideration of the bill. Thank you.
Thank you, Honourable Member. Does any other member wish to speak? Does any other member wish to speak? If no other member wishes to speak, I'll invite the Honourable Deputy Premier to exercise his right of reply.
Thank you, Mr. Speaker. Taking them in turn, thank the Leader of the Opposition for his comments. Also, it was a good start to 2024, where I had mentioned at the 2024 Chamber Forum that we needed to do more of this. If there was a question on financial services or commerce legislation, pick up the phone, talk to me, talk it through. And ironically, when the Leader of the Opposition contacted me, the ministry team and myself thought he was going to pick up on the point that the member for Newlands picked up on in relation to special resolutions. The point you picked up on, Leader of the Opposition, in relation to an exempted company converted to an ordinary company, took us slightly by surprise because we didn't really see a danger. But it shows the value of different people looking at it from different angles, getting feedback, inviting the Leader of the Opposition into the ministry so that he could understand the rationale and see where the bill was going, was a refreshing show of constructive work as legislators. I thank him for raising his questions and taking the time to meet with the ministry staff. And in relation to the comments made by the member for Newlands, yes, I think you're absolutely right in terms of the special resolution. There may have been practitioners who are a bit more assertive in certain transactions, or perhaps maybe ordinarily represent the majority shareholder. But I think once it shows the robustness of our consultation process and the reason for green billing, when it went firm-wide to some of the smaller niche areas, it was raised a concern that, hang on a second, let's think about this a bit more. We're not saying no, but maybe there's another way to do this. So it was also good, constructive to have the industry resolve within itself and not have a large debate to say, that's fine, let the rest of the bill proceed, because all the rest of it we need, and it keeps the Cayman Islands ahead of our competitors. And I'll just echo one more time the great work of the Financial Services Legislative Committee. The member for Newlands would also know just how, not just their value that he spoke to, but the amount of work that they've done. The list of proposed legislation 10 years ago was, I think, maybe 12 or 14 items long, and through the years they've been whittled down to maybe only 2 or 3 remaining items. So the challenge when we met with them last is, folks, we need some additional new ideas, because government has done its part over the years, successive administrations, to reduce the number of new ideas, and now the onus is more on them to bring the government further ideas. And as always, thanking one more time the ministry, the team, ably led by Chief Officer Dax Basdeo and legislative drafting. With that, I commend the bill for its third reading.
Thank you, Honorable Deputy Premier. The question is that a bill short entitled the Companies Amendment Bill 2024 be given second reading. Those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. Accordingly, the Companies Amendment Bill 2024 has been given a second reading and is set down for a third reading. Madam Clerk.
Civil Proceedings, Closed Material Procedures, Bill 2023.
Honorable Attorney General.
Thank you, Mr. Speaker. The Speaker begged to move the second reading of a bill entitled the Civil Proceedings, Closed Material Procedures, Bill 2023.
Does the Honorable Attorney General wish to speak thereto?
Yes, Mr. Speaker, thank you.
Honorable Attorney General, I hope you're not going to read that whole binder.
No, Mr. Speaker.
Otherwise, they would ask for suspension now.
Mr. Speaker, I tried to be as concise as possible. But it is a bill that requires a bit of clarification, so I think, in fairness to members of the public and the honorable members, colleagues in this House, I'll be a little bit granular. But, Mr. Speaker, I rise on behalf of the government to present the Civil Proceedings Closed Material Procedures Bill 2023. And as set out, sir, in the Memorandum of Objects and Reasons, the bill, Mr. Speaker, seeks to provide for the use of what are known as closed material procedures in civil proceedings, and to provide for the appointment of attorneys known as special advocates for such procedures, Mr. Speaker. The bill consists of 17 clauses, which I will speak to in due course. But before doing so, Mr. Speaker, I would, with your leave, wish to provide some background to this bill and what it seeks to achieve. Mr. Speaker, the genesis of the bill was a legal challenge brought by two prisoners who in 2016 were transferred to the UK to serve their respective sentences pursuant to the Colonial Prisoners Removal Act of 1884, which is a UK statute which was extended to the Cayman Islands as well as other overseas territories. Some members of this House, if not all, Mr. Speaker, may recall the circumstances leading up to the transfer. And just for what it's worth, Mr. Speaker, I would touch briefly on some of the facts, and will do so by what was outlined in the Privy Council ruling, which was issued on the 3rd of March 2023. Mr. Speaker, this was a case where the two prisoners who were involved had been convicted of a murder that was committed at a bar in Georgetown, Grand Cayman. And, Mr. Speaker, they were convicted of murder in May of 2016. The murder, Mr. Speaker, was described by the trial judge, the late Justice Quinn, as a very public execution of the most evil nature. Chillingly clinical in its planning and execution. Mr. Speaker, the Court of Appeal in the judgment appeal from observed that the facts of the murder bear all the hallmarks of a notorious local gang. In December of 2016, the appellants were sentenced to life imprisonment with a minimum term of 35 years and 34 years. One was given 35 years, the other one was sentenced to 34 years. They were sent, understandably, to HMP Northwood, which is the only male prison in the Cayman Islands to serve, where they were sent to serve their sentence. Their appeals against conviction and sentence were dismissed by the Cayman Islands Court of Appeal in December of 2018. Mr. Speaker, in June of 2017, following warrants of reception signed by the Lord Chancellor in the United Kingdom, orders were signed by the United Kingdom Secretary of State for the Foreign and Commonwealth Office, which caused the prisoners to be transferred to the United Kingdom pursuant to powers conferred by the Prisoners Removal Act 1884, as I mentioned. In June of 2017, notices of concurrence, Mr. Speaker, notices of concurrence were signed by the then governor of the Cayman Islands. And it is the decision of the governor, Mr. Speaker, to concur with the Secretary of State that was challenged by the application for judicial review and which resulted in an appeal. They were both transferred to the United Kingdom prisons in June of 2017, Mr. Speaker. The transfers to the United Kingdom were effected in accordance with the colonial legislation, and it was on the ground that there was no local prison in which the prisoners can properly undergo their sentence. The removing authority under the Act is the Secretary of State, acting with the concurrence of the Governor. Mr. Speaker, in practice, the Act of Concurrence is issued by the Governor, who is also empowered to direct removal by warrant. What resulted, Mr. Speaker, was a series of court hearings. So after having been removed to the UK, in December 2017, both prisoners were granted permission by the Grand Court to apply for judicial review of the Governor's decision to concur with the Secretary of State's decision to remove them to the UK. And what followed was a lengthy course of legal proceedings, which included hearings of preliminary issues, such as where is the best place for the matter to be heard, and the availability of closed material procedures in the Cayman Islands. Also, whether certain material could be withheld from the prisoners on the grounds of public interest immunity, as well as a determination of the substantive grounds of challenge, Mr. Speaker. Mr. Speaker, on the 2nd of July 2020, the Grand Court of the Cayman Islands ruled that because there was no legislation, there was no jurisdiction to hold a closed material procedure in the Cayman Islands. And Mr. Speaker, I will come on to explain later on the issue of what a closed material procedure entails. But the Grand Court ruled that because there is no legislation in the Cayman Islands, there could not be such a procedure. And so in October of 2020, the Governor's Office applied to withhold certain material from the applicants on public interest immunity grounds. Now, these materials are some of the material that the Governor would have seen and which prompted or informed his decision to remove the prisoners to the UK. Information, mostly intelligence, Mr. Speaker. So the Governor applied for public interest immunity to withhold some of these material on public interest immunity ground. Simply mean that it would not be in the public interest for these material to be disclosed, Mr. Speaker, because it would be injurious to national security, and of course it could also potentially lead to harm to third parties. The application was upheld by the Grand Court on the grounds of national security and threat to third parties. The application for judicial review by the prisoners, Mr. Speaker, then proceeded to the Grand Court, and the Grand Court dismissed the application for judicial review. The prisoners then appealed to the Court of Appeal, Mr. Speaker, and the Crown also appealed to the Court of Appeal and did against a decision by the Grand Court that they could not have closed material procedures because there was no legislation. So there were two sets of appeals before the Court of Appeal. The prisoner's appeal was dismissed in April of 2022. But on the issue of the availability of closed material procedure, the Court of Appeal disagreed with the Grand Court and held, Mr. Speaker, that such procedure was available in the Cayman Islands, even though there was no legislation to facilitate it. The court therefore ruled that this closed material procedure should proceed. Mr. Speaker, what resulted was then an appeal to the Privy Council. So the prisoners appealed to the Privy Council. It was the final appellate court for the Cayman Islands. And, Mr. Speaker, during that historic sitting in the Cayman Islands in November of 2022, the matter was argued before the Privy Council here. It was argued when the Privy Council sat here in November of 2022. The Privy Council pointed out, Mr. Speaker, that in the UK, the statutory authority to hold a CMP is conferred by Section 6 to 14 of the Justice and Security Act 2013, and that conversely, there is no statutory basis for CMP in the Cayman Islands because there is no such or similar legislation. So the Privy Council disagreed with the Court of Appeal that you could have a CMP proceedings in Cayman in the absence of legislation. The Privy Council's position is that you will need legislation before you can have a CMP proceeding. The Privy Council went on to make it clear, Mr. Speaker, that it is simply not open to the Court of Appeal to invent a CMP for the Cayman Islands under the guise of the development of the common law. The court said this would be considerably more than an incremental development. It would be a major change involving an inroad into fundamental common law rights. The court continued that such a step should be taken, if at all, by the legislature, which is better placed than the judiciary to assess the policy considerations relating to the necessity for such a procedure and the practicalities of its operation. It would also be open to the legislature, Parliament, to define with precision the scope of the exception and to make detailed procedural rules to regulate the procedure. This is paragraph 51 of the Privy Council ruling, Mr. Speaker. So the Privy Council then sent the matter back to the Grand Court for hearing on what is called an open basis. That is, Mr. Speaker, that some information has already been disclosed to the two prisoners, and the court thinks that there was sufficient material there on which a proper hearing could be conducted without, even if the other materials were not disclosed to them. Mr. Speaker, in November of 2023, the matter came up for hearing before the Grand Court for determination of the remaining substantive issues, which include the proportionality and the fairness of the appellant's removal for the purposes of Section 9, which is the Bill of Rights section dealing with the right to family. And, Mr. Speaker, we are awaiting that judgment from the Grand Court. So there was a rehearing, and we're awaiting the outcome of that. The hope, Mr. Speaker, was that we would have had the legislation in time for the rehearing. But, of course, the appellant and the Crown was happy enough to go ahead with the hearing without the legislation being in place. Mr. Speaker, the bill before this House is for the most part in line with the provision of Part 2 of the United Kingdom Justice and Security Act 2013. It mirrors in large part what is contained in that UK piece of legislation. That legislation, Mr. Speaker, the explanatory memorandum summarizes the objective of this exercise as follows. The Green Paper noted an increase in the number and diversity of judicial proceedings which relate to national security-related actions. In many of these cases, the facts cannot be fully established without reference to the sensitive material. However, this material cannot be used in open court proceedings without risking damage to national security. Difficulties arise both in cases in which individuals are alleging government's wrongdoing and in cases in which executive actions or decisions taken by government are challenged. There have been occasional cases resolved by the use of closed material procedures with the consent of both parties. However, the UK Supreme Court ruled in a case named Al-Wahari and others versus security services that a court is not entitled to adopt a closed material procedure in an ordinary civil claim for damages. The court held that it was for Parliament to decide whether or not to make a closed material procedure available in such proceedings. The Green Paper, Mr. Speaker, with your leave, continued. The Green Paper considered that in cases involving sensitive material, the court may be prevented from reaching a fully informed judgment because it cannot hear all the evidence in the case. Under the current system, the only method available to the courts to protect materials such as intelligence from disclosure in open court is through what is called public interest immunity. A successful public interest immunity application results in complete exclusion of that material from the proceedings. And any judgment reached at the end of the case is not informed by the material. It doesn't matter how central or relevant it is to the proceedings. Mr. Speaker, the public interest immunity procedure is where the government have information that is extremely sensitive concerning, for example, national security issues. And during a trial, the government would like to rely on it, but it is so sensitive that it cannot be disclosed to the other side. And therefore, a government is faced with a choice. Either you disclose the material, which would then damage national security, or you discontinue the case. So what the government usually does is, if it is too sensitive to be disclosed, they will go to the court and apply for what is called a public interest immunity to protect the document or the information, which is that it is not in the public's interest to disclose the material. And the court, if the court agrees with the application, it means that that information, that material, cannot play any part in the hearing at all. So it is not available to the government or the Crown, and it is not available to the accused. So no reliance can be placed on it by either side. So that information has no role in determining the case. In respect of closed material, in respect of closed material procedure, Mr. Speaker, which of course is not available in criminal cases. Can be used in criminal cases because the position is that in criminal case, if you're going to convict someone, they must be able to see all the information that you're going to rely on to convict them. And if it is too sensitive for you to show them, then you can't use it in the trial. So it's different. So the closed material procedure is not available in criminal cases. It is available in judicial review cases. It's available, for example, if someone is in the Cayman Islands who is not a Caymanian, and the government wishes to deport that person on national security grounds. and in seeking to do so, the government is relying on certain intelligence that is provided to it. If the intelligence is one which, if is shown to that person, will cause a damage to national security, then that information cannot be disclosed to that person for the purpose of the deportation hearing. But what will happen, Mr. Speaker, is that during the hearing, assuming that the person tried to judicially review the decision to deport him, the material, the sensitive material it is called, can be shown to the judge, and to protect the other person's interests, a special advocate, a special lawyer is also appointed, who is independent. And he's appointed by the Attorney General usually, but independent of the Attorney General, and he is there to protect the person's interests. So he will then be able to look at that material, although he cannot show it to his client.
Honorable Attorney General, I'm sure you mean he or she.
He or she.
Yes.
Sorry, I better say that person. Yeah. Thank you, Mr. Speaker. So that person's interest is protected by what is called a special advocate. But the special advocate cannot show the material to that person. However, he can make submissions to the judge about the use of the material, including whether it is too sensitive, whether he agrees that it is too sensitive not to be disclosed and so on. But the person's interest is protected in that regard. And if the court concludes, or the judge concludes, that information is relevant but it is too sensitive, the court will then use the material to make a determination as to whether the person should be deported or not. And so it is a compromise, so to speak, because what it means is that the court will have the best information available to it. Sorry.
Point of elucidation, Mr. Speaker.
Please proceed.
Yeah.
If the Honorable Attorney General is prepared to give way.
Thank you very much, Honorable Attorney General. The special counsel, just for clarification, just for my own, that person's appointed is by the Attorney General? Okay.
Yes, Mr. Speaker. So, thank you, Honourable Member. So, in the UK, what it is, they have a panel, a number of persons, like 10, 15, 20. They are called special advocates. They are appointed by the Attorney General, so he would look at the list and determine who should do it. That attorney, once he's appointed, is no longer answerable to the Attorney General. He is completely independent of the Attorney General. It doesn't report back to him, has no connection or interaction with the Crown. And the relevance of, well, just to clarify, that it also happens in cases where the Attorney General is not a party to the proceedings. It can be any other civil matter where the Attorney General is not involved, but that person is appointed. And the person has to be provided by the state with all the resources to be able to carry out his or her job, independent, again, of the AG's imprimatur or intervention. And so there's a list of special advocates who carry out that role. And as I said, he or she is required to make submissions on behalf of the person, and the interaction is between that person, that attorney, that advocate, and the court and the judge. So, Mr. Speaker, what happened in the closed material proceedings is that the intelligence is available to the court, And so the court will be able to see whether, for example, what the governor says he saw and acted on, whether it is credible. The judge will be able to make that assessment. However, as I mentioned before, if it was a public interest immunity application, it wouldn't be available to the court to make any decision on. Because public interest immunity, once upheld, means that neither side can rely on information. It's not of benefit to either side. This is a sort of a compromise where the information is available, but it can be shown to the opposite party. It can only be shown to the judge and the lawyer, the special lawyer, who is appointed by on his behalf or her behalf. So that is the distinction, Mr. Speaker, between the two. And it is understandably not without a bit of controversy. But the question is whether, as I mentioned to you before, if you have a situation where someone is in, use the Cayman Islands, and well, might be here legitimately, but is not a Cayman, and is involved in subversive activities, terrorism or whatever it is, and the person needs to be deported based on intelligence because he or she is a threat to national security. The question is whether the state should have the ability to remove that person without having to disclose certain information to the person, which then would jeopardize national security. Although a judge can see, a judge might disagree, having looked at it. A judge might take the view that I don't agree that this rises to the level that it would jeopardize national security, and therefore I'm ordering you to disclose it to the accused person or the opposite party. So, Mr. Speaker, it has also closed material procedures and special advocates have also been used in some family proceedings. And this predated the use of it in the UK. One example is in 2010, a case involving a child, Mr. Speaker, who was made a ward of the court following his abduction by his father. The central focus of the case in considering the child's welfare was an allegation that the father had allegedly taken out a contract for the murder of the child's mother. However, the police wished to withhold information and the source in order to protect the investigation. A special advocate was used to test the underlying material, including by way of cross-examination. And it's a case of wardship, Mr. Speaker. The use of the closed material procedure is also permitted in proceedings before employment tribunals in the UK pursuant to the Employment Tribunals Act and regulations made under that act. So what the Justice and Security Act 2013 did in the UK, Mr. Speaker, was to allow the closed material procedure to be used in civil proceedings more generally, including proceedings for damages such as negligence or breach of contract actions and for injunctive relief and in judicial review cases. I mentioned that it's not just cases where the Attorney General is involved in or the state is involved in. It can be purely private matter, but that person, the special advocate, is appointed by the Attorney General from a panel, Mr. Speaker. Mr. Speaker, the general premise is that, I think I mentioned, I explained already what is a public interest immunity. And I would not propose to repeat that, Mr. Speaker, but there is also the possibility of providing a gist, Mr. Speaker, of the allegation, a synopsis, if you will, gisting, it is called, to the other side without having to disclose the entire material. Mr. Speaker, significantly, and the point which I touched on earlier, the result of a successful claim to PII is that the evidence in question is wholly excluded from the proceedings, and neither party may rely on that, and neither can the judge. And Mr. Speaker, that was exactly the position in the prisoner transfer challenge, Mr. Speaker. Considerable material relevant to the governor's concurrence with the transfer decision was withheld from disclosure on public immunity ground for national security reasons. The confidentiality of the material was preserved, but the Crown, Mr. Speaker, could not rely on that material as part of its defense that the concurrence was lawful. In other words, Mr. Speaker, even though the governor had credible material about the reason for removing these two prisoners, there were some of it that the court could not use because of the public interest immunity decision that was made by the Grand Court. Whereas if there was a CMP, the court would have been able to look at it and concur with the governor. In this case, of course, the Court of Appeal and the Privy Council said, well, notwithstanding those other material that was not disclosed, there was sufficient other information which was provided to the other side, which allowed the proceedings to proceed in a way that would not cause any injustice as such. Mr. Speaker, the question is whether such a procedure is compatible with human rights. Where, Mr. Speaker, material must be withheld on PII grounds, a properly authorized closed material procedure is not incompatible with the right of access to a court under Section 7 of the Bill of Rights, which is the right to a fair hearing. The Cayman Islands Constitution Order, or Article 6 of the European Convention, provides for a right to fair hearing. The European Court of Human Rights supported, a case law supported the use of this procedure, Mr. Speaker. Those cases, Mr. Speaker, also provide that safeguards may be required, but these will be dependent on the context, notably the nature of the right that is engaged, and what exactly is at stake in the individual and the particular interest in withholding the material. So, Mr. Speaker, special advocate may be required, and where more fundamental rights are engaged, such as those under the right to liberty, which entitle a person to challenge the lawfulness of his or her arrest, the disclosure of the gist of the material is permissible. Mr. Speaker, just to point out that closed material procedures are not unique to the United Kingdom. Similar procedures from which a party or parties to the proceedings are excluded, while sensitive material is under consideration by the court, are used in a number of European Union countries, as well as in Canada. In the case of Canada, Mr. Speaker, these procedures are permitted by laws such as the Immigration Refugee Protection Act and the Evidence Act, and that has been held to be compatible with the Canadian Charter of Rights and Freedoms, Mr. Speaker. So, Mr. Speaker, against that background, I mentioned before that the bill mirrors the UK legislation, and I would just like to touch on a few areas in the bill itself. Some of it has to do with definitions. I mentioned before that it is not available for criminal proceedings. In criminal proceedings, everything must be disclosed or can't be used at all. The closed material jurisdiction is intended to apply to relevant civil proceedings before the Grand Court or the Court of Appeal and, of course, the Privy Council, and does not include criminal proceedings, Mr. Speaker. Mr. Speaker, the definition of sensitive material is also in the bill. The UK Justice and Security Act defines the term sensitive material by reference to material, the disclosure of which would be damaging to the interests of national security. Under the bill before this House, the definition goes further to include national security and other public interests. And this is to avoid being overly prescriptive. And Mr. Speaker, I mentioned to you before that you could have instances where third parties could be at risk if such third party, for example, provide the state with intelligence. So, Mr. Speaker, in terms of procedure, Clause 3 of the bill deals with what is called a declaration as to proceedings. Clause 3 provides for the starting of the CMP process. So the first stage of bringing a closed material proceedings in case of a relevant proceeding is by way of an application under Clause 3.1 for a declaration that the proceedings are proceedings in which a closed material application may be made. Translation, Mr. Speaker, depending on the intelligence that the party has, one party has, if it doesn't want to disclose it to the other side, that party will make what is called an application to the Grand Court for a declaration for the court to look at the nature of the proceedings and to say, I agree that this is a case in which a closed material proceedings would be appropriate, and so I'm going to grant you the declaration. Once that is granted, the party will then outline to the court the nature of the material that it has in its possession, which cannot be disclosed. And if it gets to that stage, then a special advocate would be appointed to also look at the material that the party is declining to disclose. Mr. Speaker, may I just point out that in the hearing itself, the only part of it that is closed is the part of the hearing that deals with those material. The rest of it is ordinary hearing, where witnesses are called, cross-examination, everything else is disclosed and discussed. The only aspect of it that is closed procedure is those aspects of the case dealing with the sensitive material. Once that is out of the way, then the trial proceeds as normal in the normal adversarial way. So it's not the entire proceedings that is closed. So. Mr. Speaker, the Grand Court will be guided by rules that are drafted by the Grand Court Rules Committee. So the Grand Court Rules Committee, comprising the Chief Justice, the Attorney General, 2 lawyers from private practice, will craft rules that will set out the procedure as to how the entire proceeding should be conducted. And those will be what will guide the court throughout the proceedings and to ensure that there is, in fact, Mr. Speaker, fairness in dealing with the closed material or the sensitive material, Mr. Speaker. Mr. Speaker, I touched on the appointment, clause 11, persons who may act as special advocates. I touched on those already. And I mentioned that among other things, the Attorney General is also required to ensure that the special advocates are provided with adequate administrative support and resources to carry out their role, Mr. Speaker. In the UK, they have what is known as a Special Advocate Support Office, Mr. Speaker. And they act independently in providing support to the special advocates. I imagine, Mr. Speaker, well, not imagine, similar arrangement will have to be made in this jurisdiction, but the scope will likely depend on the frequency of closed material procedure taking place here. I suspect, Mr. Speaker, that this is a provision that is likely to be hardly used at all. And I suspect most of it will be used, if at all, again, would be perhaps where we're dealing with deportation cases, where persons might be required to be deported from the island for national security reasons. Thinking about it, Mr. Speaker, I recall many, many years ago, a particular gentleman was deported to Jamaica from here, and it was very credible intelligence that they had, which could not have been disclosed to him. He went to court, and the judge at the time was persuaded by what was told, what was made available to him, such that could be shown that there was a basis to have his exclusion from the jurisdiction on national security grounds. So we have had instances of that, Mr. Speaker, albeit it was not dealt with by way of national closed material procedure, but we have had that some time ago. Mr. Speaker, the bill also provides, Mr. Speaker, for a review of certification. So clause 10, Mr. Speaker, provides that a party can challenge a decision of the governor to declare material sensitive, where he does so under section 9.3. Any such challenge will be dealt with in accordance with the principles which will be applied in judicial review proceedings. So, Mr. Speaker, it's not just a matter of the governor, a governor, or a party for that matter, or a cause suggesting that this is sensitive material and so it can't be disclosed. The other side is at liberty to challenge the characterization of the material as too sensitive to be disclosed. And the court can make a decision as to whether or not it ought to be disclosed and to be relied on by both sides, or be available to both sides. Mr. Speaker, clause 12 deals with the making of regulation. This clause provides for cabinet to make regulation for such matters as may be necessary or convenient for carrying out or giving effect to this act. And it includes regulations of transitional or savings provisions. Clause 13, Mr. Speaker, speaks about the Rules Committee. I mentioned that before. The Rules Committee referred to in the bill is the Grand Court Rules Committee, constituted under Section 19.1 of the Grand Court Act. Matters falling within its rulemaking powers are set out in Section 19.3. These include prescribing forms to be used, making rules for the taking of evidence, and rules regulating pleadings and procedures for the conduct of civil business. Mr. Speaker, the special advocate will enjoy immunity under Clause 14, provides an immunity for special advocates in respect of any acts done or omitted in the discharge or purported discharge of that function. Of course, there is no personal liability except, Mr. Speaker, where it can be shown that the special advocate acts in bad faith. Instructively, Mr. Speaker, Clause 15 contains a reporting mechanism under which the Attorney General is required to report annually and initially for a 12-month period from the date on which Clause 3 comes into force. And this report is to be made to Parliament, Mr. Speaker. And the report to Parliament would include information such as the number of applications in the reporting period, the number of declarations made by the court, the number of revocations made by the court, that is, where the court having granted an order, the court having examined the issue, has a change of heart and decided to disallow the use of closed material procedure. The number of closed judgments as well, Mr. Speaker. So all of these will have to be contained in a report that will be tabled in Parliament every 12 months, a 12-month period. Mr. Speaker, Clause 16 of the bill establishes a framework for the conduct of an independent review of the operations of certain clauses of the bill, clauses 3 to 8, Mr. Speaker. And that must be done as soon as reasonably practicable after 5 years from the date on which Clause 3 comes into force. The reviewer, Mr. Speaker, is appointed by the governor, who may compensate the reviewer for any expenses incurred in carrying out his or her function as well. A copy of the reviewer's report must be laid before Parliament by the Attorney General. However, before doing so, the governor may exclude from the copy any material that the governor considers, Mr. Speaker, to be too sensitive. Again, only if it would be damaging to national security or endanger the life or safety of any person. That is included. Mr. Speaker, there is a transitional provision, and that is in Clause 17, the effect of which is that in relation to any proceeding that is currently pending, the legislation will enable a closed material procedure to be held. So, Mr. Speaker, if the current prisoner transfer challenge continues after this bill is enacted, and say there's an appeal and they wish to avail themselves of the provision of the Act, then it would be available to them, Mr. Speaker. I mentioned to you that the matter has been reheard. The judgment is pending before the Grand Court. I don't know whether there will be an appeal, whatever the outcome, whether there is likely to be an appeal. But if there is an appeal from that judgment, either side might want to seek to try to avail themselves of the provision of this legislation. And so, most likely, a court would accede, because if the court thinks that there are material that the governor had and the Secretary of State had that were material, which basically crystallized their view about the danger of these prisoners being kept here, but it was not available because of the public interest immunity. The court would want to see that material to satisfy itself that, yes, there was credible intelligence which informs the position that they should be sent abroad. As it is now, some of that material was available to the court and available to the prisoners. There are others that were cogent, but it was too sensitive to be disclosed. So the court was not able to use it. The governor couldn't rely on it. The prisoner couldn't rely on it. So that is excluded from the procedure altogether. So, Mr. Speaker, that hopefully explains the purpose of this bill. As I said, my expectation and anticipation is that this is something that is going to be extremely sparingly used. But the Cayman Islands is not afraid like in other cases, to take the lead as OTs in the enactment of these sort of legislation. And we know what usually happens once it happens here, then other overseas territories tend to follow suit, and so assuming that they face similar challenges, Mr. Speaker. But all in all, it is a very helpful piece of legislation, useful piece of legislation to be had or to be on the books in the event that it is required. We have, and I kept saying this, we have a very transient population here. We do have undesirable persons who make their way here from time to time and might be involved in activities which require their removal on national security grounds. And it might very well be that the information, the intelligence that is available to inform that decision is so sensitive that it cannot be disclosed because it will compromise national security as well as compromise the safety of others. And so if that is the case, then this piece of legislation would facilitate a process where the court can look at the information and make a determination one way or the other. And so, Mr. Speaker, I would commend the bill to honorable members of this House. I would like to thank those who have been involved in the drafting of it, the legislative drafting department, Solicitor General and Deputy Solicitor General, as well as Legislative Council. And I'm happy to answer any question arising, Mr. Speaker. I commend the bill to honorable members.
Thank you, Honorable Attorney General. Does any other member wish to speak? Honorable Leader of the Opposition.
Oh. Thank you, Mr. Speaker. Mr. Speaker, thank you for I rise to give and to indicate from the opposition standpoint that we support the bill that is before this honourable House. I do have to admit, when I first saw the draft, it was released, I had great misgivings about it. More so because I just simply did not understand it and what it was seeking really to achieve as a result of seeing it. I also know that the Attorney General has alluded that the UK has similar legislation. I think they've had it since probably, what, 2012? 13. Okay, close enough. But anyway, they have this legislation in place. And I do know it wasn't without its controversy when it was introduced, and there were misgivings about it. But the government of the day succeeded in having it passed, and for all intents and purposes, just as we have indicated here, it's used very rarely, very rare cases when it's used, but it has been found to be extremely useful in those circumstances where it has been used. Mr. Speaker, the Attorney General kindly arranged for the opposition to be briefed by his office on this bill last week, Monday. We had met for a good while with him and with the Solicitor General, talked through the basics of the draft bill and what they were seeking to achieve. As a result, we left with a much better understanding and feeling much better about the bill and the contents of it. And so, Mr. Speaker, we're able to come this evening and indicate to this Honourable House that we fully support it, and I commend it as well. So thank you, the Attorney General, and to the Solicitor General for meeting with us and providing us with the explanations that we required, and for enlightening us on the provisions of this bill. Thank you, Mr. Speaker.
Thank you, Honourable Leader of the Opposition. Does any other member wish to speak? The Honourable Member for Borden Town West.
Thank you, Thank you very much, Mr. Speaker. My comments is actually quite brief on this bill. Similar to what the Honorable Leader of the Opposition said, I too had, I guess, certain reservations about the bill, but I do accept, especially in light of even what we're dealing with right now, that there are times within our own society, our own community, that we do require certain legislation to be in place to deal with certain issues that may arise from time to time. Now, the thing about it, Mr. Speaker, that caught my attention on this bill was actually what prompted it. And it went back to the Colonial Prisoners Removal Act of 1884. And it kind of really, I guess, jumped out to me that in this day and age, when we have to be relying on laws that are over 100 years old to deal with something, and then when you also consider, Mr. Speaker, that the Colonial Prisoners Removal Act, or thereabouts, was enacted in 1884, and then you look at the events of what was happening in 1884, it kind of set the tone as to why that act came about to begin with. And for the listening public and for members, it was actually the year of the same Great Berlin Conference when the European powers got together and decided to divide up Africa amongst themselves. And I guess anyone in Africa that was given trouble, they basically just shipped them to the UK to deal with them. So that was pretty much the genesis of that law when it was enacted in 1884. Bear in mind that many colonies didn't have a proper prison at that time and so forth. But I do understand in this day and age now where you have terrorism and everything else, and you're relying on the public to provide certain information, that there is some level of national security or some level of protection that is needed. So we do understand the need for this legislation to be on the books and everything else. And as such, while it is sad that it is something that is necessary in this day and age, nonetheless, it is a tool or a resource that the members in the law enforcement community will actually need for such. So with that said, Mr. Speaker, I will too support this bill. I think it is something that is needed. Again, just the signs of the times of where we're living now. Thank you.
Thank you, Honourable Member for Bodden Town West. Does any other member wish to speak? Does any other member wish to speak? If not, then I'll invite the Honourable Attorney General to exercise his right of reply.
Thank you, Mr. Speaker. Mr. Speaker, thanks to all honourable members to begin with of this House for their support. Thanks in particular to the Honourable Leader of the Opposition as well. We met and clarified the objectives as set out, as he quite rightly pointed out. Mr. Speaker, I think I find the observation of the Honourable Member from Bodden Town West quite appropriate. The timing of the reading of the bill is quite fortuitous. And as he rightly points out, we are in a period now where, given current happenings, Mr. Speaker, intelligence is quite important. The provision of intelligence is quite important. And we certainly, as a parliament, would want to encourage the provision of intelligence by those who have relevant information, on the understanding, Mr. Speaker, that their safety will not be jeopardized should they be brave enough to come forward and provide it and so. But as I said, the timing is just fortuitous, really. And so his observation is quite apt in the circumstances. Mr. Speaker, just to point out that this bill was approved by Cabinet in August of last year. and it has been in the public domain since then by way of public consultation. And so it has run its course many times over, 28 days and over, and so. And members of the public would have had an opportunity, Mr. Speaker, if they wish to provide comments or feedback. We did have a couple of feedback on the bill, and which was quite welcome, Mr. Speaker. And so with that said, Mr. Speaker, I thank all honourable members for their support of the Civil Proceedings Closed Material Procedure Bill 2023. I thank you, sir.
Thank you, Honorable Attorney General. The question is that a bill shortly entitled Civil Proceedings Closed Material Procedures Bill 2023 be given a second reading. Those in favor, please say aye.
Aye.
Those against, no. I think the ayes have it. Madam Premier, may I invite you to move motion for the adjournment of this House until 10 a.m. tomorrow morning.
Thank you, Mr. Speaker. Mr. Speaker, I move that this Honorable House be adjourned until 10 a.m. tomorrow morning, Tuesday.
The question is that this House do now adjourn until 10 a.m. tomorrow, Tuesday, 27th of February. Those in favor, please say aye.
Aye.
Those against, no. I think the ayes have it. Accordingly, the House is adjourned until 10 a.m. tomorrow morning.